We are have up till now covered different topic of IBC. Now here onwards, this section 7 application is very common topic. It is actually done very much time. So you all may be thinking what all new. The thing what we are going to add on, which I was always considering that, the decided cases. So what we are going to do is that respective section, all the relevant case laws, we are going to take care. So we know the section 7 process, rules, regulation, but we are always stuck that yes, okay, 2 months back, this was the case law, but whether any development, what is recent situation? For example, acknowledgement of debt in case of section 7 application. Earlier it was yes, in balance sheet, if it is shown, it is there. Again, no. Then again appeal, yes. Then again, no. So we don't know as on today what is the status quo. So that is to be carried out. And here it is, that's the reason we are carrying out this session. And the main, our intention here is to carry out and provide decided cases of different terms used in that section and relevant case laws. So one will have a kind of, holistic approach to that particular provisions. And today we are starting with section 7 application. We have none other than this today, our own partner from Ahmedabad, Mr. Rishabh Shah. And I think I'll request him only to introduce. And also the presentation is done by our own Elizabeth. And also Jaswin Bindra will join in few minutes. Yeah, over to you.
Hello, ma'am. Thank you so much for your great introduction. Myself, Rishabh Shah, recently joined Mehta and Mehta last week only. So I'm into practice as a company secretary since last 5 years and qualified as an insolvency profession. I'm not into the IP, qualified insolvency profession. I've just qualified limited insolvency examination. And I'm very grateful to join Mehta and Mehta as a team member. Thank you.
Fine. So without wasting time, and friends, I request you all to put your questions in chat box, which will be answered by the presenter and Rishabh and Justine and as such. And Elizabeth, you can start the presentation. Thanks a lot.
I'll just share the screen. So good evening, one and all present here. Myself, Elizabeth. I am under the legal team of Mehta and Mehta Insolvency and Restructuring LLP. So today the presentation is on the topic of initiation of CIRP under section 7 of the code. So we are trying to limit it because it is a vast section and very common application section which is used by the NCLT and the IBC code. So there are various ways of CIRP initiation under section 7, 9 and 10, but we are only taking section 7 application today in this webinar. So as we all know, there has been a paradigm shift in the insolvency regime as of now, wherein the insolvency regime in India is dealt and administered under the IBC code instead of Companies Act right now. So the procedure under the code is can be used to restructure a corporate entity and its finances, failing which there are provisions in the code to maximize the realization for the creditors. So the CIRP under this code is an expedient tool to protect apparently insolvent but potentially viable corporate entity from liquidation. So under this code, the court oversees a structured negotiation among the creditors while deputing a resolution professional for the corporate entity to be a mediator. And then the creditors may come for a settlement of their debt and interest with a new one. But if the creditors fail to come into a consensus, then they go for a resolution plan given the majority. So this is a overall procedure, but today we are going to go by the step by step by looking into major case laws and the applicability of the section 7 of the code. Since we have a very less amount of time, we will be majorly focusing on the case studies, that is landmark case laws, which has been dealt under section 7 of the IBC. So before going into the initiation process, there are various basic elements of the process which has to be defined and looked into before going into the procedure. So the first such definition is financial debt, which is covered in the section 5 clause 8 of the IBC code. But since the definition is very big and wide, it is an inclusive definition and not exhaustive one. But if you go by the basic definition, financial debt means a debt along with its interest, if any. So we have to always consider that if any also, because that has been considered in various case laws. So a debt along with the interest, if any, which is dispersed against the consideration for the time value of money. So this is the basic definition of financial debt, which is given in the code. And also it includes various other elements of debt, but I have not included the definition, literal definition as such. But since the code is in the nascent stage, the NCLT and the adjudicating authority, appellate authorities have given various interpretation of this definition to give a wider approach of the same. So rather than going by the definition part, we will look into some of the major landmark cases in this under the definition. So coming to the first case law is Neil Industries versus Jawan Mining and Constructions Equipments Limited. So this is a landmark case law where they have dealt with the major element consideration for the time value of money. That has been dealt under this case law. So in this case, the court has stated that if there is a, if they have to show that there is a financial creditor, they are a financial creditor, they have to show there is a money borrowed by a borrower dispersed against the consideration for the time value of money. So there has to be a time value attached to the money borrowed by it. It can be through any instrument, but the consideration for the time value is given as the main factor in this case. So such kind of amount which has been borrowed through bonds or debentures, all these modes can be used. It may not be directly to the corporate debtor. It can be through any instruments. So such kind of debt dispersed against the consideration for the time value of money. So there should be a consideration for the time value attached to the amount borrowed. That is which is considered in the Neil Industries Limited versus Jawan Mining. Now, going into the Dena Bank case law, here one of the main thing which they have considered is one-time settlement. So when we consider whether an acknowledgement of debt is involved within the scope of a financial debt, we consider if the financial creditor or the borrower is proposing a one-time settlement as a remedy within the limitation period that is coming under the financial debt, and that can be considered as an acknowledgement of debt. So that is one of the main inclusion in the definition of financial debt. Again, similarly, in Tejas Kadahar and versus Bank of Baroda, and also Vivekanand Jha versus Punjab National Bank, in all these cases, they have considered, the Supreme Court has held in, that is in Dena Bank, the Supreme Court has held that one-time settlement can be considered as acknowledgement of debt. In Vivekanand Jha also, they have considered that it should be in the limitation period. So when we go into the limitation period, Section 18 of the Limitation Act is stating that the CARP process is, the limitation period for the CARP process is given as 3 years. So if the acknowledgement is made within the time frame of the limitation, then they cannot dismiss the application stating that the CRP initiation is time barred, because there has been always an acknowledgement by in terms of balance sheet. It is shown in the balance sheet, or it is there in the one-time settlement. If they have proposed a one-time settlement, that all comes as an acknowledgement of the debt. So when you consider the time limit of limitation, it extends from the date the acknowledgement has been made. So that has been considered in all three cases, Dana, Tejas, and Vivekanand Jha. So
Adding to this, in case of a financial debt and a financial creditor, this has been the major point in many cases of one, what is the limitation period, and second, what would amount to an acknowledgement of debt, thereby extending the limitation period for that transaction. So like she's already said about OTS settlement, there have also been instances of acknowledgement of debt, whether a balance sheet inclusion amounts to acknowledgement. And in these cases, a lot of forums have decided separately on these matters. So as on date, if we see the law, certain tribunals have held that a balance sheet acknowledgement may amount to an acknowledgement of debt, thereby increasing the limitation, and the others have taken a contradictory view. So there is a need for a little more clarity on this. Rishabh, your inputs on this?
See, ultimately, acknowledgement of debt, there are various Supreme Court judgment also, which says that, if the corporate debtor has acknowledged that there is a default by way of signing a form, or in case of, any contract or not, it should be considered. And in case of, this COVID-19 extensions and all, so there are a lot of confusion at present. So it should be should be cleared.
yes. So as of now, they have tried to consider most of these. They are trying not to dismiss the application just because the limitation, they have not filed the application within 3 years. Any kind of acknowledgement they are trying to involve under the financial debt and trying to take up the application if it is a genuine as such. Now, going forward to the Pioneer Urban Land and Infrastructure Limited versus Union of India case. In this case, this is a landmark judgment where they have tried to include the amount given by the allottees of a real estate project as a financial debt. So that the amount which the allottees have put, in most of the cases, there is a vital interest in the amount that are advanced by the allottees in the project. Sometimes it may be that 100% of the funds may have been put forth by the allottees for the project to be completed. So in that case, they have tried to put their amount also under the definition of financial debt. And the court has also mentioned that when you're dealing with the allottees and the real estate matter, there is an act, that is RERA Act. So you have to try to make a balanced approach and give a harmonious interpretation when you are comparing the RERA Act and the IBC code. So only when there is a conflict, the IBC code will prevail over the RERA Act. Unless and until that, even the concurrent remedies should be given to the allottees under the IBC code as well. This has been held in the the court has held that they have to be given the concurrent remedies, and they have also the Supreme Court has also confirmed the constitutional validity of keeping the allottees of the real estate project as financial creditors under the code. So they have tried to include who can be defined under the financial code and what can come under the financial debt by this case. So there are two inclusions put forth under this case. So that is one of the major landmark judgment which has been made. Now going into the Bhaskar Vishwas.
Before you take that up, Elizabeth, Pioneer definitely, as she said, was one of the landmark cases, and more importantly, because one, there was a lot of conflict between RERA and IBC at that point. So there was a clear demarcation of when you can go ahead and file your proceedings under RERA versus when you can go ahead, when the home buyers can go ahead and file an application under Section 7 for initiation of CIRP. More than that, another important point is initially when the code had set in, I know there are a lot of seniors, so they may appreciate that they had not included the allottees or the home buyers in the definition. However, by way of an amendment that was introduced, and subsequently they've also put in the limit of the number of applicants.
So, sir, you have to add on any point into this.
There's a question as well, Bajrang Lal Sharma, sir. In case the auditors qualified the financial accounts and audit report, then will it be termed as acknowledgement of debt?
Okay, thank you.
Rishabh, you will take that. You want to take that up?
Yes, I got your point.
Okay, he's clear now.
Because the auditors generally qualify the accounts by putting their adverse remark in audit report. In listed company, where this is also required to be filed with the listing department of the respective stock exchange under regulation 30, I think. When the auditors are qualifying the audit report, then it should be the acknowledgement of the debt, according to me. But what is your view? I don't know. What should be the rationale of this acknowledging the debt? My point
So
is.
In my view.
Yeah.
Sir, yes, sir. Please, sir. You wanted to add on something, Bajrang sir?
No. Okay, you continue.
Yes. So in my view, it depends on what part of the report has been qualified. So if the auditor has qualified the debt itself, then there can be a dispute about it. It can amount to, then in the NCLT in its view can consider if that can amount to an acknowledgement of debt or not.
I want to add one more thing, because
yes,
auditor generally also report about the financial health of the company, stating that they are performing the terms and conditions and covenant contained in the various agreement with the bankers who have financed the company's proposal and project. And they also mention in their report whether they are willful defaulter or not willful defaulter. So this is also condition is for the RBI guidelines.
Right.
So, to my mind, I think this should be the trigger point. If the auditor qualifies the account, that means it is understood that they have acknowledged the debt.
Right.
Okay, you continue, please. Okay.
Thank you, sir. Now, if I move on to the next case law, that is Bhaskar Vishwas, Suspended Director of Oxford Facilities Management versus Avani Oxford Owners Association. This is also a recent case law where they have tried to include another financial debt. In this case, they have stated that the amounts collected by the developer and kept with its subsidiary, the corporate debtor, for purpose of maintenance till the association or holding organization gets established to hand over the amounts to the body of the flat owners. This amount collected by the developer will also fall under the definition of financial debt. So here they are going to focus on section 5.8 subclause F, where they are trying to see whether the debt involves any commercial effect of the borrowing. So in this case, they are stating that the financial creditors were not sleeping over the rights, and they were trying to contact with them and get the amount back, and they were trying to keep intact. So there was no sleeping over the right, and there is a commercial effect of borrowing. So this amount which is used for the working capital of the association or the holding organization. Again, they are saying that that amount also falls within the definition of financial debt. So they are also stating that if it is again coming under the minimum threshold limit, which we will deal on the next section, if that is also being fulfilled, that requirement also being fulfilled, such amount collected by the developer will also come under the definition of financial debt under section 5. Now, going into the Pawan Kumar versus Utsav Security. Ma'am, do you want to add something in that? Okay, so I'll move on to the next case law, that is Pawan Kumar versus Utsav Security Limited. So in this case, they are trying to state how the financial debt can be established. So here they are trying to focus more on the evidence which is in place and any kind of contractual agreement or any contract as such is available to show the existence of financial debt. So in this case, what happened is that though the corporate debtor had taken loan from the creditor, there was no financial loan agreement as such to show the tenure of loan or the interest of the loan or tenure, the rest of the details of the loan. So here the NCLT has held that relying on the IB adjudicating authority rules of 2016, there has to be a financial contract as per the rules, wherein they have to show that there is a contract between the financial debtor, creditor and the corporate debtor, setting out the terms of the financial debt, including the tenure of the debt, the interest payable, and the date of repayment. So in this case, there was no document to produce and show that there existed any financial debt. And also, the court tried to establish that the deduction of TDS cannot be a basis of the transaction to show that there existed a financial debt. So they tried to exclude the TDS transaction under the scope of financial debt to show that there existed a financial debt, but also try to include that there should be some kind of contract between the parties along with the details laid down in this case to show that there existed a financial debt. So since that was absent in this case, there was no agreement as such. The court dismissed the application stating that the creditor was not able to prove any financial debt as such. There was no evidence to prove as such. So that was in the Pawan Kumar case. So in all these cases, we are trying to get various elements which will make form a part of financial debt. So either it can be an acknowledgement part, or it can be evidence of default part, or who will who and what will form a financial debt. These cases are dealing with various elements which form the financial debt.
Even today, on the basis of pursuant to this particular decision, many benches of the NCLT do not consider the deduction of payment of TDS as a valid proof for the financial debt. So this has in many cases changed the practice in a lot of benches of the NCLT. There is another question. Yes, Bajrang Lal Sharma says, sir says, whether negative working capital is considered as capital since net worth is in most of the cases is eroded. Rishabh, you want to take that up?
See, ultimately, negative working capital is eroded. It's fine. It's about as per the audit report, right? But as per the books of accounts of the bankers book evidence or records of the information utility, the amount has been dispersed. So it should be taken on record. The records as per information utility, the default record, and the amount dispersed by the financial creditor.
Bajrang sir, do you have anything to add to that?
I want to add just only one thing.
Yes,
If
sir.
the debt is more than 6 months, it is not realizable, then bank has to make the provision NPA. And I understand ki what people you are saying that ki if provision is made, even the debt is also there. So it is
Yes,
because I
yes,
understand, got the point. Thank you.
yes.
Hmm.
Okay.
Yes. Thank you. Thank you. Yes, Elizabeth, you can continue.
Yeah. So next case is S. Chandra versus Sunil Kumar Agarwal resolution professional. So in this case, again, they have tried to exclude a kind of amount from the definition of financial debt, that is earnest money deposit. So earnest money deposit is kind of an advance amount which is given for sale of land and as such. So they have stated that there is no element of consideration for the time value of money involved in the earnest money deposit in such transactions. So they have held that the acknowledging the liability of earnest money as a financial liability is not akin to the admitting it as a financial debt. So they are again trying to exclude a kind of debt away from the definition of financial debt. So they are always considering the main factor of consideration for the time value attached to the money borrowed while considering a debt or the money given by the financial creditor. So in this case, they have considered the annual return on the financial year in these matters, and they have tried to go by the amount, and it was not fulfilling the requirements given under the financial debt definition. So they tried to keep the earnest money deposit away from the scope of financial debt. So that is one of the other exclusion under this case. This is also a recent case law which has been held. So that is it. Now, anything to be added? Anyone has to add to this point? Anyone?
Oh, there's a question in the chat box. In one case, travel agent went into IBC in December 2021, and the airlines has refunded money to Akbar Travel to refund to the client. Can Akbar Travel ask for NOC from RP of shoes on Loose Private Limited, the agency via whom tickets done?
The question is not clear.
Yes.
Can you unmute and say that what is your question?
Yeah. One of the case where 4 tickets were done by Shoes on Loose. The company went into bankruptcy in December. The file has been done. And now the client who has booked the ticket through Shoes on Loose was following up with Thai Airways. So they refunded money after 2.5 years. And
I'll interrupt. Sorry, this is very particular case with a very detailed, details we need to study. It will be difficult to answer in this kind of webinar. If you mail us, that will help us to answer. But here we will not able to, because we have to understand the facts. It is factual study. Okay.
Yeah. Yeah.
Thanks.
Okay,
Thanks a
fine.
lot.
Thanks.
Yeah. Yeah, Elizabeth, continue.
Yeah. So one of the other recent case law is MS Orator Marketing Private Limited versus MS Samtex. So in this case, it is a case where there is a critical analysis which has to be also made. So here the issue which was considered was whether an interest-free loan can be put as a financial debt under the section 5 clause 8. So here the Supreme Court has held that the definition or the meaning or the interpretation should not be done in isolation and should be considered in the context, and check the records of the information utility, the evidence in default. And they have stated that such kind of interest-free loan can also be put under the definition of financial debt, because as per section 5 clause 8, it starts with, as I earlier mentioned, a debt along with interest, if any. So the Supreme Court in this case has specifically emphasized on the words, if any, to prove that even if there is no interest, that debt can also be taken as a financial debt under this clause, considering the facts of the case. So in this case, this amount, the loan was considered as a working capital, which was needed. And also, so even if the interest is not involved, that has to be considered as a financial debt. And also the court has considered commercial effect of the borrowing, which was also present in this case. And they have also considered the section 5.8, the definition part, which starts and also uses the word includes. So the definition as such is inclusive in nature and it is not exhaustive. So considering all these factors, the Supreme Court has held that interest-free loans can also be put under the definition of financial debt. So here the main question arises is the element consideration for the time value of money, whether the profit or the current time value attached to the money, whether that has been considered. So that is not considered in the case of this Orator Marketing Private Limited. So that is again a precedent which has to be considered and checked with. Ma'am, Jasvi ma'am, you want to add on to this?
Yes, so this Supreme Court judgment had actually changed a lot of ideas. Before this, it always used to be said that what is important for any transaction to be counted as a financial debt is there should be a time value of money involved. What this judgment had turned to say is time value of money does not need to be only in the form of money or in the form of interest per se. It can be in any other form. So therefore they had said that interest-free loan, it can also, if it has an angle of time value, then it can also be amount to a financial debt. I think we also have a comment on this. Bajrang sir has said that interest-free loan is defective. It lacks of consideration. Sir, can you expand on this?
Yes, I want to say,
Yes.
if there is a contract, I am giving the loan to my company, private limited company, without any interest. My intention is not to recover that interest also. If the interest is not there, where is the consideration? What is the consideration of my loan? So yeah, here the concept of the contract of consideration, one of the main condition of the contract should be lawful. Without consideration, the loan should not be termed as a contract and should not be termed as a perfect loan, because consideration point is missing there.
Right.
Because in most of the private limited companies, promoters generally give the loan to the company, because promoter is the only source of finance to the
Right.
private limited companies. So
Right.
in case of difficulty, only promoter can finance and they provide the interest-free loan. Then their intention is not for recovery and not for earning the interest even. Then how can we say that this is the perfect debt? Because their intention is not a debt. Because if the debt is there, then consideration must be there.
You are perfectly right. You are perfectly right. And it was considered as a contribution to the capital. And there are many decided cases.
Yes.
And we ourselves has done well with that. And it is considered as contribution to the capital.
Yes,
as rightly someone mentioned, it is
I
called
agree
equity.
with your point. Thank you very much.
Yeah, so but the thing that's why we are telling this case is really interesting and something different. And that's why we are telling that's how it is changing, because up till now we were fighting and time value of money was so important. Everyone was studying that any loan you need to have time value. But this particular case has changed. That's why we are telling that, and that's why, we have thought that let's discuss the case, how its swings are happening. It's yes, no, yes, no. So that's why you are perfectly correct.
Okay, thank you.
But this is the decided case. We have to accept that. Okay, thank you.
Okay, thanks. This is reversing
Another
the
point.
entire concept.
Yeah.
Even though there is no agreement available with the creditor, but the debtor shows in the balance sheet as debt, whether such debt could be termed as financial debt. There have been decisions by the NCLT as well in certain cases that there needs to be some supporting document to justify the debt. other than just mention in the balance sheet. So wherein, something like a resolution passed under the Companies Act or any contract, there has to be some concrete supporting document for the
No,
finance.
documents for supporting, you provide the goods, services, there should be supporting.
Right.
That kind of supporting you should have from your end. As regards the supporting from the company, that whether you have that proof, that acknowledgement of that is that balance sheet. Because since if you have sufficient proof of provision of goods and services, or not goods and services, I mean to say providing finances, so you have your own proofs that the fund was transferred, then if that acknowledgement, that surely it can be, there are cases. So actually speaking, facts of the case is depend, but in principle we are talking law, legal principle, or the crux of the law, or the same facts can be accepted. So yes, it is accepted, acknowledgement of that, but mere acknowledgement of that may be the question.
Right.
You have your own proof is required. Thank you.
Yeah.
Elizabeth, yeah, continue.
Thank you. Yeah, so I have by this we have tried to include major elements of the financial debt, what cannot be considered as financial debt, what can be considered as financial debt. And the last case is one of the controversial case law, which may be considered in later on in future cases, because consideration for the time value of money has to be also taken into consideration ahead in other cases. So that is about the financial debt. So any person who is having a debt along with interest or not disbursed against the consideration for the time value of money can be considered as financial debt. And the literal definition is given under section 5.8, which includes other definitions also. So now going on to the next definition is financial creditor. So who comes under the definition of financial creditor is any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to. So in this case, the legal assignment and transfer has to be again showed through any kind of agreement, that is assignment agreement or the transfer agreement, to prove that he is being assigned with, or any person to whom. So if it is himself or by jointly or with other creditors, is again we have to consider. Now again, the court has given a wider approach to involve who all will come under the definition of financial creditor. So some of the case laws include Dr. BVS Lakshmi versus Geometrix Laser Solutions Private Limited. So here also they have tried to keep the element of consideration for the time value of money in the amount involved to make it as a financial creditor. So if the claimant claims to a financial creditor, he has to show this element is present. But the recent case law is again putting a point on this consideration element. But going on to the Palogix Infrastructure Private Limited versus ICICI Bank, they are trying to exclude a major class of people away from the definition of financial creditor. So a power of attorney holder cannot file any application under section 7, 9, or 10 of the code. So here, what they have stated is that under the adjudicating authority rules, there is form 1 through which we are filing the section 7 application. So section 7 application is giving us the form 1 is mandating that if you are authorizing any person, that person's name, address, everything has to be given, and a declaration has to be provided by the financial creditor for whom that authorized person is acting on behalf. So simply by being a power of attorney holder as distinct from the authorized person cannot himself be entitled to file any application under section 7. So just because he is a power of attorney holder doesn't constitute him or authorize him to file an application under section 7 of the code. He has to be authorized by the financial creditor as per the rules, adjudicating authority rules of 2016. So this has been another major observation made by the adjudicating authority. Anything, ma'am, has to add? Anything has to be added, ma'am?
Yes.
No, I think,
Yes, Deepti ma'am.
no. Yeah, you go ahead.
Yes. So, yeah, what they have basically distincted is authorization and power of attorney has two separate meanings. So, under this code, we need an authorization, and it's not necessary that a power of attorney would amount to that. So, that's the only distinction. Yes, Elizabeth, go ahead.
Yeah.
I have one observation.
Yes, sir.
Can I continue?
Yes, sir.
Yes, sir. Please.
I think the intention is that that person should be that power of attorney, if supported by the board resolution, then to my mind it is perfect. I think
That's
if the
right.
board resolution is supported and the power of attorney is supported by the board resolution, backed by the board resolution, then it is the intention of the company to initiate the proceeding.
Yes.
Okay. Thank you.
Absolutely right, sir. Absolutely right. 100%.
So,
can I just add here?
Sure, sir. Please.
So I think only as contended by you, only the board resolution or the authorization is mandatory, but the power of attorney might not be there. This is what the court contemplates, right?
Yes. So, if you're merely giving a power of attorney, that does not suffice.
That
You
does not
have
suffice.
a board resolution, that's again fine since you're authorizing the person. If
Right.
you have a board resolution plus a power of attorney, that is again perfect.
All right. I get it.
Yes.
Thank you.
So next two cases are another major opening which the court has made available to the financial creditors. That is, even if they are not resorting a CRP against the principal borrower, it is always open to the financial creditor to commence CRP under section 7 of the code against the guarantor. Sorry. So in this case, they are stating that when the guarantee becomes a debt, as soon as they invoke a guarantee, the contract of guarantee, and they will be put under the shoes of the corporate debtor. So here the court is trying that they are not, the guarantors are not escaping from their liability on behalf of the corporate debtor. So it is not always they have to go and file against the principal borrower, but they can always go against the guarantors and initiate the corporate proceedings. Now, what all will, so in the case of guarantor, how the moratorium is fixed, those all things we will deal in the upcoming session, upcoming slides. So in this case, they have stated that the CRP proceedings can be initiated either against the principal borrower or the corporate debtor, or against the guarantor. Whether it can be initiated simultaneously also has been dealt under this various sections and cases that we will look into it later on. So now going into the State Bank of India versus NS Engineering Projects Private Limited. In this case, the court has tried to view from the perspective of the corporate debtor. So here the court has held that a contributory negligence from the side of the financial creditor by its own acts of omission or commission which contributes to the default on the part of the corporate debtor. In such cases, they are liable to dismiss such kind of application. So in this case, what happened was that the financial creditor itself contributed to the negligence by non-disbursement of the amount which was sanctioned through the loan. So here, since the financial creditor himself have defaulted, the court stated that this application cannot be allowed. So contributory negligence was also considered. So always the court is trying to balance the matter, balance the approach, and trying to view it from the point of both the corporate debtor and the financial creditor. Yeah, so that is about the State Bank case. Anything to be added?
Madam, I want to add one point only.
Yes.
We are saying that the corporate guarantor are responsible prior to the main debtor. So it is practical, it is fair without going to the against the main company where the debt is there. We are invoking the proceeding against the corporate guarantor. It is fair.
Legally correct.
So it's
It is
all
already-
derived. Yes, ma'am. Yes, ma'am. Deepti ma'am, please go ahead.
Yeah, we will take that cases also, because recently that is very well settled, that it is not necessary to go first against the corporate debtor and before initiating action against personal guarantor. So it is settled, but since you asked, there are cases, but we are taking one by one cases, because each I will say topic has several cases. So we are taking this along with later on. But yes, what you have asked is correct. And the court has decided, even though CD has not been, the action is not taken, IBC process is not started against CD, personal guarantor can be taken case. I myself is there
Because
in one or
I want to
two
add,
cases.
I
where-
want to add one more thing, because
Yeah.
each and every
Yeah.
company is a separate entity. That corporate guarantor, that corporate guarantor may be a listed, unlisted, maybe a big corporate. If you are taking action against that corporate guarantor, I think it will be in the interest of the public also.
Yeah, so that's why, see, they are telling, the court has decided the creditor has right to decide from where they want to recover. When they
Right.
have given, so that's why when default is there, they have right from to whom they want to start the action. Any other law cannot decide that no, you cannot do it. And it's settled now that not necessary. So that cases also will take how it was decided and moved. But yes, since you have asked the question, it is well settled.
Okay. Thank
And
you.
also,
As on
sir,
today.
adding
As
to
on
it,
today, huh? I must say as on today.
adding to it, it's only derived from the simple word which says the liability of the person, of the borrower and the guarantor is always joint and several, irrespective of the order where you go ahead. This is the simple line that attracts all of this. And that's also been written in the judgment, where it says the liability is joint and several. That settles a lot of things then.
Ma'am, can I ask a question, please?
Sure, sir.
Respect of the last judgment, could it be a case, could it be in the favor of the CD that a financial facility is arranged and advanced by the financial creditor to the CD? However, the agreement which is entered into is not duly stamped. It is signed by both the parties. The CD has made the default of the financial arrangement, and that is by way of emails also. But the agreement in first place is not stamped, and neither are the work orders. So can he take a plea that it is a default on the part of the FC and the amount is not payable? So it's a default.
There is a
financial
recent
creditor. Can
case.
he say?
I Elizabeth, note down this query. There is a recent case, and in which NCLT is decided just because there is a NCLT or NCLT, I don't exactly remember. There is a technical problem in the documents. The transaction per se itself cannot be negated. So if there is a loan, you have proof and all that, but that agreement is technically incomplete, does not say that FC is not FC, and it can be done. That is a decided case.
All right.
Just technical glitches cannot, or technical errors cannot amount to omission and commission. It has to be something more than that.
Okay,
but then this technical thing will also be subjective, whether it amounts to technical or a procedural difficulty or
implication of that can vary.
Per se, I can say that if you can prove that yes, there was a financial transaction, we have given the money, but that agreement is not stamped, or it is less stamped kind of thing. So it's fine. It's a understamp. So that is different penalty for that, different requirement is there. But per se, the transaction, financial transaction, you cannot say that it never happened when there is a sufficient proof. And that's why IBC should not start. That is not there, and the court has accepted, and the insolvency is started.
So, ma'am, in one of our own client matters, what happened was that they entered into an agreement on 1st of April, for example, 22.
I will request I
Okay.
request again, I said that this cannot, in principle law we can discuss, but the
Okay,
facts
all
we
right.
cannot
No
make.
worries.
So
Well, I'll
yeah,
ask.
we can
Thank you,
connect
thank
separately.
you.
Yeah.
Sure. Thank you, ma'am.
Yeah, thank you. There is a case question which it says that FC settle overseas, and how to initiate the process since power of attorney is not possible. Why power of attorney is not possible if the FC is settled overseas?
No,
Can
ma'am,
you?
they are stating that they have to just authorize them, and the authorization has to be given properly. They, just because you are a power of attorney doesn't as such make them authorized to file any application. The proper authorization should be done as per the rules of adjudicating authority rules.
Yeah,
That is what is
and
given,
even
right,
though
ma'am?
they are, yeah, no, there is a question. They are telling that FC is settled overseas, and there is no question of power of attorney. How what is the remedy available?
Actually, the difference is, ma'am, in the judgment that we have discussed, Palogix in the infrastructure, that was a company. So for that, authorization will mean a board resolution, etc. backed one. But since in this case it's an individual, then power of
Individual.
attorney, yes, then there's no problem for a power of attorney. That was in case of a company where they said so.
So it should be supported since company is a separate entity. It requires that it should be supported. It's a not natural person, required supported by the board resolution. That is the main thing.
Right.
Since it's not a natural person, here it is a natural person, they can give power of attorney. It itself will, of course, as per the rules, you have to execute power of attorney. There is another question also in the chat box. That is in case individual, even though there is no agreement available with the creditor, but the debtor shows in the balance sheet as debt, whether such debt could be termed as fine. I think we have considered this, right? This question.
No, we've taken that. We've taken that.
Yeah, okay. I think then we answered. Yeah, Elizabeth, go ahead.
Okay, ma'am. Thank you. So here about the corporate guarantor also, in these cases, we are trying to consider who comes under the definition of financial creditor. Rest of the details about the situations where the corporate guarantor, the Section 7 application is initiated against the guarantor will be considered as per different elements involved in the process. So this is just about the financial creditors, who will be and who will not be considered as a financial creditor for initiation of Section 7 application. Now, if we go for the applicability of Section 7, who all can
No, Elizabeth, we are running short of time. It's 6 o'clock.
Okay.
If you are starting new topic, we should. I was knowing this, friends. This kind of presentation, concentrating mainly on the decided case, we have started from this session, and there will be series of session. I would like your suggestion whether this way we should carry on these sessions, because now in this Section 7, all this way financial creditor, then who can apply this way, all relevant cases, each term wise we will take. I hope you find interesting. Then we there is a next session based on this way on decided cases only, and that will be after 15 days. As we know, bi-monthly we are holding this same 5 to 6 Friday. So Mr. Summe, I agreed for half an hour, but there is an issue today for us, for panelists to continue. And if new topic, it may continue more than half an hour. So that's why, yeah, I agree. That's why section wise the case laws, because we take piecemeal sections law. So I appreciate everyone is agreeing. I myself was feeling, this was required as a IP. Every time we are getting so stuck today. Okay, earlier it was financial debt, now it is there or not. We are not knowing today. So that's why I wanted this way, that each IP or any advocates would like to know, they can refer it. And I will say that each one to participate and share the knowledge. Friends, we will hold this, complete this session today itself here, as and
ma'am,
we'll
before
come
we
back again.
close, there's a comment by Bajrang sir in the comments section. Holding company may issue BR for subsidiary company. We did not consider that.
Yeah. So he has given the comment actually, not a question as such. So that's why I'm not.
Okay,
Okay.
okay.
Okay. Thanks everyone. Thanks friends. Next time again we'll meet, and this we will continue for section 7, 8, 9, 10. This we will carry on all the section. Yeah, we'll share the PPT to every registered participant. Okay. Thanks a lot. Thanks again. Come with this number. We'll surely share all these sections and we'll continue sharing knowledge. Yeah, we'll put a session. I honestly, next session, let me declare only, just give me some time. It can be on 9th, Friday, 9th September. Okay. Thanks a lot. Between 5 to 6. We'll again come with that. Thanks, everyone. Thank you.
Thank you, ma'am. Thank you.
Elizabeth, excellent presentation. This
Thank
way only I wanted. Friends, I appreciate Elizabeth, lot of efforts in this. She has worked a lot on this presentation. Very good presentation. Thanks.
Thank you, ma'am.
Thank you, Elizabeth.
Thank
Mr.
you, sir.
Rishabh, thanks
Thank
a
you,
lot for your
sir.
time.
Thank you, sir.
Thank you,
Thank
ma'am.
you, sir.
Thank you.
Thank you.